thought I'd do a really brief video. I didn't have time to do it yesterday, where I read the portions of the transcripts about juror number 6 and also now juror number 7. Now, today is Tuesday. We've had court for the 17th. This is for yesterday, Monday morning, the 16th. This is when we found out that there was another juror. And now we know it's juror number 7. And TMZ, came up with this exclusive information that they had. Okay, let's get into these transcripts. Let's start the read and see what the judge said Monday morning. Let's go. Hit the like button. Next, let's briefly discuss juror number 6. First, I hope the parties understand that the reason we have discussed this issue several times over the past few days is that I understand its importance, and that I want to make sure that I've considered all arguments from both sides that have been presented. This amount of scrutiny is not required. As the court previously observed, the Second Circuit in United States versus Fazio confirmed that the removal of a juror is prerogative of the court and does not require the consent of any parties. Indeed, the court noted in Fazio, the federal rule of criminal procedures do not require any inquiry prior to the dismissal of a juror. With that, last Friday, both in the morning and in the afternoon, we discussed whether there was cause to dismiss juror number 6. In that morning, I expressed the preliminary view that further inquiry of the juror would be appropriate because the record, as it stood, was insufficient to justify removing the juror. The government's position was that the record of the juror's conflicting answers during voir dire and from last week's roving room discussions suffice for removal. In their view, the inconsistencies raise serious questions as to the juror's candor and his basic qualifications to serve. The government did not object at that time to further inquiry of the juror if the court deemed it necessary. But the defense indicated that further questioning of the juror would have a negative impact on the juror that might impact the deliberations going forward. That's from the transcripts at page 6031. I didn't reach a decision at that time, but rather took time to consider both sides' submission and arguments. Now, the defense observed in its June 15th letter that in the morning of Friday, I offered that there could be ways to reconcile the juror's testimony, that the record, as I saw it at that time, would not be enough for dismissal. I then did what judges are supposed to do. I thought about what the parties had said, the authorities they raised, and I went back to look at the record closely to make sure that I was making the right call. Over the course of the day, during breaks in the proceedings, I re-reviewed the transcript in jury selection and from last week's roving room discussions, as well as the authorities cited in the party submissions. The issue was further addressed at the conclusion of the day. As I indicated at that time, after further review, there were clear inconsistencies between the jurors' voir dire answers given under oath and the jurors' answers during the roving room discussion, and further inconsistencies within the roving room discussion itself. Taking these all together and considering the arguments laid out in the government's June 11, 2025 letter, the record raised serious concerns as to the juror's candor and whether he shaded answers to get on and stay on the jury. These concerns are amplified given that the subject matter of the inconsistencies, where the juror has lived and with whom, go to straightforward issues as to which there should not have been any doubts. And the answers also go to something vital, the basic qualifications of a juror to serve. To top it off, the inconsistencies and shifting answers on that issue raise questions about the juror's candor as to the numerous other questions asked by the court in the juror's questionnaire and in-person voir dire's process, threatening the integrity of the judicial process. On this basis, the court indicated that juror 6 should be dismissed. Now, while the defense questioned the relevance and importance of the inconsistencies, they did not deny that they existed. The defense invited the court to further question the juror to see if he could explain them. This despite the earlier expressed concerns about chilling the juror. The defense cited a concern with reducing the diversity of the jury by replacing a black juror with a white one in reference to the Second Circuit decision in the United States versus Slaughter, which raised questions concerning the underrepresentation of Black and Hispanics or Latino jurors on veneers in this district. The court took the weekend to consider the defense's argument, and it takes seriously the defense's concerns about race, diversity, and the issues raised in Slaughter. Taking into account all of the circumstances presented, further inquiry of the jury is inappropriate, even if this juror had an excuse or explanation for the inconsistencies in the record. That would be yet another set of shifting answers on basic questions about the juror's residence. This would only heighten the specter that jurors trying to shade answers in an effort to remain on the jury. In other words, there's nothing the juror could say at this point that would put the genie back in the bottle and repair the damages to his credibility. Further, the court agrees with the defense that even if the court were inclined to retain the juror, which could only happen if further questioning that inquiry would almost certainly have a negative impact on the juror, that might impact the deliberations going forward in a predictable way, potentially compromising the jurors' functionings. As the court observed on Friday, this is precisely why we have alternate jurors. We're not equipped in this settings to do a forensic investigation into issues raised. So we have alternate jurors precisely for this kind of situation, to avoid even the appearance that the fair and impartial nature of the process had been undermined. As to concerns about diversity and Slaughter, as the defense itself noted on Friday, this jury does not raise those concerns. Defense counsel Mr. Donaldson himself observed that this is the first time I could say in this 25 years we have this type of diversity in the jury in this district, and that the process that this court used for us to get the jury to work and work wonderfully, in that we got a diverse jury. The defense also agreed, given the discussions that we had on Friday, that there was no intentional discrimination at play in the issue raised as to juror number 6. Now, it may not be intentional, Mr. Donaldson. It's not. It's clearly not. He's quoting Mr. Donaldson from, the transcript that we all read. Make sure you check out that video. No one is saying that's what happened. The defense asked this court to base its decision-making on race, but it would be improper to allow race of juror number 6 and alternate jurors to factor into the proper course here at all. The Supreme Court has prohibited precisely that kind of injection of race into the process. As the court observed in Batson versus Kennedy itself nearly 40 years ago, the defendant has no right to a petty jury composed in whole or in part of persons of his own race, because the number of our races and nationalities stand out in a way of evolution of such a concept of demand of equal protection. The court there confirms a person's race simply is unrelated to his fitness as a juror. Now, the current situation is obviously not governed by Batson, which involved preemptory challenges, but the import of that decision is straightforward. The court should not, indeed cannot, let race factor into the decision of what to do here. At that point, the answer is clear. Juror number 6 is excused, pursuant to Federal Rule of Criminal Procedures. He will be replaced by the first alternate juror. As to the other accusations against the prosecution lodged in the defense June 15th letter, there has been no evidence of prosecutorial misconduct brought to the court's attention. Zero. To the extent that these accusations are an effort to pressure the court to make a decision on a juror issues before it based on race, the court rejects that invitation. If the defense has a specific good faith application based on any of the issues raised in its letter or anything else, then it should make that application. In each instance, in this case where an application for any kind of relief has been raised, this court has given it close attention and has resolved it many times in the defense's favor. But inviting the court to make a decision based on race would be doing what the Supreme Court for decades has flatly prohibited. As for the separate juror issues, okay, pay attention. Now we're getting to separate juror issues on page 10 of Monday's transcripts, June 16. As for the separate issues that we addressed on Friday, let me say a couple of things. First of all, the issues concerning the two jurors are in no way linked. Okay? Bullet point 1. The court will apply the same standards and procedures as to any jurors' issues that arise, applying non-discriminatory criteria and the governing standards to determine whether there are grounds for dismissal and proceed based on what the law and facts dictate. Trying these two issues together, urging race to factor into the process, and then suggesting that if the outcome isn't in the defense's favor, a mistrial is warranted, has no basis in law, logic, or basic notions of fairness and justice. The government says it does not oppose further questioning of this juror. So, at the conclusion of the day, after the remaining jurors have left, we will ask that juror to stay so that I can ask questions that the parties have for me to ask. The parties should meet and confer on that score and furnish to me an agreement set of questions. They should also confer to the method of questioning, whether we should clear the courtroom and have the questioning occur here, or whether the parties agree that the questioning can occur in the roving room. That resolves the issues concerning the two jurors. On Monday, juror number 7 was mentioned. There was a sidebar at some point when they were doing direct with Penland. Penland, again, is the summary witness for the prosecution. Yesterday, there was a sidebar regarding Penland. The court asked at the sidebar, did the parties discuss what they wanted to do in terms of juror number 7? Shapiro says, no, we received an email from the government and we haven't had a chance to confer internally. The court says, should we handle this tomorrow? Shapiro says, I think that's fine with us. So tomorrow being today, the 17th, giving you guys an idea. And then sometime at the end of the day yesterday, Shapiro asked for the defense, Your Honor, we were just wondering if the court could just tell us some sort of what, if anything, was told to the other jurors when juror 6 was dismissed. We were sort of concerned on the impact that might have on the remaining jurors, so we wanted to inquire as to how it was dealt with. The court says, let me figure that out, and then I'll advise the parties when we start on Monday or Tuesday. Okay, so that's everything that happened as it pertains to juror number 6, and then there's 7, right, who's currently looks like being investigated, or at least things are being looked into. TMZ drops a bombshell yesterday about what is happening with this juror. I'm thinking it's this juror, number 7, right? And I'm wondering, and I think that's why the court this morning, I showed you guys these messages with Jewel Mancy. Here's the clip. Jules Mancy is there. Inner City Press is just now waking up and in there. So I don't think he caught up all of this, but let me tell you what's going on. So juror number 7, judge says jurors were told not to discuss why juror 6 was dismissed, only that they were excused. There's also a separate issue involving juror number 7. We'll handle that after today's testimony. Okay, so then judge says one or more people in this courtroom or those present on Friday flagrantly violated the court orders. This is a flagrant violation of the court orders. Violators will be punished, possibly with criminal contempt or sanctions. The judge further says the court imposed a gag order on the government, the defendant, and all attorneys for the defense and anyone involved. Everyone was made accountable. Violation of the order, what happened here, may result in civil or criminal contempt charge for all involved. The judge says, I'll be investigating it. There's no passing the buck. The buck will not be passed. It stops there. Okay? The buck stops with you. If anything happens, lead counsel is responsible. Somebody go get somebody because somebody leaked something here. Who's the angry man in the podcast? That's what I want to know. A close source at TMZ. Remember that? They were upset. The judge was upset and basically saying, like, somebody leaking information here from the attorneys. Somebody's saying something, or maybe not. Maybe it's not even like that. Maybe it's the jurors itself. Who knows? Let me know what you guys think in the comments. I just wanted to do a really quick video breakdown of what is going on with the jury. Okay. Now, let me just say this. I really want us to get us through this trial. Can we get through this trial without any more mishaps? I mean, we only literally have this week and next week, and maybe the first week of July. We'll see. Let me know what you guys think in the comments, and I'll see you guys on the next one. Rabbits out. Bye, guys.